first case is State of Ohio versus Green. The state has waived oral argument, Mr. Lowry, so you will have 15 minutes with which to present your case. Please don't use the names of victims or minors when you're presenting your argument. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Attorney Lowry for defendant, Mr. Green, 0031017. I'm sure that this court, is quite familiar with this. There was a original appeal filed in this case, the Green 1 case. In fact, I believe Judge Teodosio dissented in that opinion, but the court ruled that the matter should go back based upon, I believe it was assignment of error number 4. It went back to the trial court for further consideration, and the trial court issued an order which I subsequently appealed to again. I think it's important to realize, however, procedurally, something happened in between. When the matter first went back to the trial court issued an order clarifying its interpretation of how it considered Detective Gary's expert testimony and issued an initial order which was rejected by this court, mostly for procedural issues, that the order didn't encompass the entire sentencing order and therefore was a void order. As a result of that, the appeal was dismissed. I had to wait for the trial court to do it again. The trial court did it again, and then it's that order that I appealed from. I do think it's important, though, to consider the order that was done in the initial case that this court rejected because they didn't find that it had the procedural content necessary to do the appeal. And with respect to Detective Gary, and that language that the court used in the initial order, a nice synopsis of it is contained on page 22 of Appellee's brief in response to my brief in this case. In the first order, the trial court merely said that it was striking Detective Gary's purported expert testimony regarding the glass in the road, including his opinion of the significance. For some reason then, in the second order of which this case was taken appeal from, the court elaborated on that and included various other things that it also claims to not have considered when it rendered its decision. I think that's relevant because on its face, I think it presents the situation that at the time of the first order, which was not a final appeal order by this court, those items weren't listed. So it almost presupposes that those items were considered, which goes to the heart of my assignment of error number 3, which is the one I'd like to address here principally today. Specifically, I've argued in assignment of error number 3 that the court considered testimony that was not competent, and in doing so, that the conviction should be set aside. Now, my principal issue there is that this, as this court did, the court reversed this in Green 1 because Detective Gary's testimony that he proffered as an expert should have been excluded, and the court was real certain in its pronouncement. The court said that in its opinion that expert testimony here built a bridge that spanned the gap from the narrative presented by the state to the conclusion endorsed by Detective Gary. I think that's real important because I believe what the court was saying, excuse me, was that absent detectives' so-called expert testimony, the state could not get from point A to point B. Fortenberry stands for the proposition that a trial court is presumed, in a bench trial, is presumed to only consider competent evidence. And the burden is upon the appellant to prove that there's some sort of affirmative appearance that the trial court did more than. I've raised the issue that I think that is in and of itself present because of the conversations that I recited in the record where the court clearly acknowledges that Gary is being proffered as an expert testimony, and that the court, through its statements and actions, clearly said or seemed to say that lost my thought. Somebody handed me a note. I'm sorry. Clearly said that the court, in her conversation, she clearly indicated that she was accepting his expert testimony as an expert. And now the turnaround is that, well, you know, I didn't accept any of that. I didn't consider any of it, anything else to that nature. I believe the test is, for my argument for number 3, is that I have to do 2 things. First of all, I have to show that there's an affirmative appearance under Fountainberry, and then I believe I have to show that there's substantial prejudice under United States versus Great House, which is 484 Federal 2nd 805. And in that, then I have to be able to show that there's substantive prejudice. So I consider this to be a 2-pronged test, even though Fountainberry really doesn't address that, but I believe it's a 2-pronged test. And I will tell you that the case law on this issue is nominal, if best. There's some case law out of Illinois, which I've cited, that I think goes to the heart of the case. But the crux of my discussion here is that it's clear that the court, I think it's clear, you know, it's hard for me to sit here and say, well, you know, we're going to look inside someone's mind. But I think if you take a look at the record, you take a look at the first order and then the second order, I believe that it's more than apparent that the court did consider the expert testimony of Gary in its rendering its decision, particularly since this court has observed that absent his testimony, it's very difficult, if not impossible, to get from point A to point B. I believe a reading of the record, I believe that the orders taken in their context shows that there's enough of an indicia that the court considered it, that the case should be remanded for further consideration. And the case law in Fountainberry, as well as the Great House case, say that if the extent can't be discerned, then the remedy is to go back. In other words, if it can't be discerned how much, which is, we'll all agree, I believe it's impossible, the case has to go back for further consideration. So I would present to this court that a reading of the trial transcript, a reading of the orders, establishes enough indicia that there was an affirmative appearance in all of it, that the court relied upon Gary's testimony. And I can't quantify how much, but the fact that it exists, even in a nominal character or nominal fashion, compels the return of the case. The other issue with the Fountainberry in this whole thing is that it goes to the heart of my first argument and my first assignment, and that is the gravity of weight. Now, this court in Green 1 said that the sufficiency argument was in nullity because the court found that there was the sufficiency component of the conviction was there. But I would argue that absent Gary, that the weight of the evidence didn't compel a conviction. There's 3 people, there's 3 witnesses. If we take Gary out, his presumptions and everything else, I've got 3 people. I've got the defendant, I've got the victim, and I've got the woman that was in the house that, notwithstanding Appley's argument, saw the relevant portion of this encounter. Those are 3 people that all saw this, and the court noted in Green 1 that it was that there were essentially 2 sides to every story, and they said, and that the inference, and I believe it was a direct statement, that Gary's testimony that was the one that gave credibility to the victim. If I pull that out, I've got 2 people that are engaged in an argument, and I've got a third party that sees it, and the way she sees it does not comport with the way that the alleged victim claims in the record. And her testimony was believable. It was appropriate. There was no bias demonstrated. So I believe that the weight of the evidence, without Gary, once again, I think compels a finding that my first assignment of error is well taken also, and that's that the case should be reversed on a weight of the evidence argument. With that said, I appreciate the opportunity, and that's about 15 minutes.
Quick question, though, as to the woman. I'm trying to recall her testimony. Didn't she say that Green was positioned outside the driver's door of the victim and the victim was seated in the driver's door? And if so, didn't that corroborate the victim's testimony?
No, she did not say that. That's what the appellee says. If you take a look at my reply brief to the appellees, I specifically address that issue, and I point out in the transcript, hang on, I point out in the transcript where that is not the case. Hang on here. It's addressed at page number 4 of my brief and reply. Appellee also mischaracterizes an important element of this case, and then I talk about where they were located and all the issues that you just talked about. And I further in my reply brief, I also address that further, but I address that issue specifically in paragraph number 4, and I say in here, listen, I don't know where the state's getting this argument because that wasn't the testimony.
Okay, I'll look at that. Can you just briefly comment on the state's position that there was no objection at the trial on authentication grounds?
On you're talking about
On the body cam. On the body cam.
On assignment number 2?
Yes.
Yeah, I raised that argument. I would argue that any decision under that particular assignment error would have to be one as plain error.
Okay. Did you argue plain error?
I did.
Okay. Thank you.
Seeing no other questions, thank you, counsel, for your arguments today. Thank you for agreeing to appear via Zoom. The court will take the matter under advisement. We will issue a written decision, which is mailed to all parties as well as posted on the Ohio Supreme Court website. Have a wonderful day.
Thank you. Good day.